We have Evita Gosha here with us today, who is legal director and management board member at Šrenk Latvia, leading builders material producer in Latvia, which employs more than 350 people and more than 500 subcontractor employees. Also, already heard, Amit Kabrawala will join us today. He is the regional resident legal advisor with the U.S. Department of Justice Office of OPDET, based at the U.S. Embassy in Riga, Latvia. He is also a federal prosecutor in the International Narcotics and Money Laundering section. Third expert, Katrīna Pļaviņa, leads regulatory practice at law firm Vilgarts. She thus advises on GDPR, public procurement, energy, state aid and environment matters. As a procurement lawyer, Katrīna helps companies with fair tenders. During the discussion, we will go through the questions for each one of you, but already at the beginning, I encourage you also to jump in and comment on the things said by the other panelists if you want to. I prefer we start with Evita Gosha today. And first question, how does the whistleblowing law affect the human resources capacity, and who are the designated persons in the private and public sector to take care of whistleblowers' report? Please, Evita.
Good afternoon. First of all, can you hear me well?
Yes, we can hear you very well.
Okay.
And see you too.
Okay. Yes, thanks for inviting me. I'm really happy to be here. I actually happen to have a very intensive conference day today, and I actually, a couple of hours ago, I had an opportunity also to speak in another conference that takes place today, or took place today, which is a risk management conference, and it is interesting how these actually both topics risk management and whistleblowing go together. So I'm still thinking of the best ways really to contribute to this conference as well, and trying to do my best here today. Now, addressing your question. We probably find ourselves in a very interesting situation in Latvia. Because we all know that actually whistleblowing law or whistleblowers law, which we have in Latvia currently, it was introduced only a little bit more than a year ago, so which is pretty new and fresh. However, it has a long history actually of being adopted. So for actually many years, it was under discussion, but no parliament actually adopted it. At the same time, there are many private sector companies in Latvia which actually already years ago implemented different whistleblowing mechanisms really at their own initiative. So currently we have a very interesting situation that this is like a we still have both types of probably people. There are still people who think that whistleblowing or reporting about like particular issues is something similar to what we saw back in the Soviet Union times, which is a bad thing to report about something. And then we have the companies and the individuals which are actually on the having a completely different understanding and actually having a very clear understanding that that this is very beneficial, you know, that there are these instruments implemented. And I am happy to be, let's say, among those who really truly believe in the benefits of instruments of and mechanisms of whistleblowing. And I represent proudly a company which has had a mechanism of whistleblowing, and actually in a much broader understanding of this term than according to the current Latvian law we have. And so thus I'm very happy to share my experience, and also of experience of our affiliates in different parts of the world. we are currently, I think, in the situation in Latvia that we have to acknowledge that still, even though we have this law, of course, miracles don't happen, and we still will need definitely time really to educate the society in general and make them understand really that let's say, what are the benefits that such whistleblowing mechanisms provide. And definitely it also involves training of people who are even capable of implementing these mechanisms. The fact itself that these mechanisms should be established according to the law doesn't mean that like automatically, you know, like everybody will be willing and capable to implement these mechanisms. So definitely, so there are different entities, like starting with DALNA, of course, and like others, which are able and willing to spread this word in the society and educate those who have to implement these mechanisms and educate these people who have to take the leading role in implementing these mechanisms. And I think that those companies and like entities in general, all kinds of organizations which understand the benefits of the whistleblowing mechanisms, they already, while really understanding these benefits, they also devote all the necessary resources for implementing them. Definitely, as I said, the main resource, I would say, is really the understanding, the knowledge, the time, and also, of course, which is what is extremely relevant is really like creating even the atmosphere of making people believe that these instruments really work. Because as I already mentioned, the fact itself that the law prescribes that something has to be implemented, and something maybe is implemented formally, but then simply gathers dust and you know, like remains as a tool unused, it doesn't bring any benefit to anybody. So these mechanisms require actually a belief in the organization, the trust to those who actually take the leading role and who would be actually these bodies who would review the reports, hear the cases, and if there is no trust in these organizations, then this simply won't happen. So actually, what is really relevant is to make the society in general really believe that transparency, openness, policies, procedures, that this is all relevant, and only then actually these whistleblowing mechanisms can, like internal mechanisms, can really work. So yeah, I think I can finish here. Otherwise, I will just take the floor forever.
Thank you very much, Evita, for encouraging the public, us to believe in the importance of transparency, in importance of whistleblowing. Further, Catherine, we have a system in place at the moment for whistleblowers and their protection in enterprises too, who seek the opportunities to implement their internal control systems. But anyway, we hear that there are problems and solutions for them are needed. As a legal expert from your side, what improvements to the law and the system are needed? Proposals for mitigating system shortcomings? Please, the screen is yours.
Hello, everyone. Thank you, Lasma, and it's a pleasure to be here today with you. And what we're normally doing, indeed, is consulting for various companies on how to either implement a whistleblowing system, which was something that we did more than a year ago. And then what we also see is, of course, how it works. What is the day-to-day management of whistleblowing systems? And in the end, finally, how to integrate those with new understandings of GDPR laws or competition laws, etc. And what I wanted to contribute also a bit, echoing what Evita already said, and also what we heard from Swedbank, is that it is indeed, first and foremost, a question of the atmosphere or of the tone from the top, as Swedbank put it. And that is something that can be achieved only through spreading the word and training and acting accordingly whenever a company does receive a whistleblower report. And that is a big challenge. It is in general not a problem with companies which have Scandinavian capital. That's in general, their compliance culture is I would, in my opinion, is much higher than all the other companies here. But what is most important, of course, is that it is so ingrained into the culture of the company that really the atmosphere is there. The question is there are there any legal tools how we can promote that in the companies which do not yet incorporate these values fully into their everyday business? And I think that there are two things that we could do. First of all, the main critique that the legal community delivered after the adoption of the law was that companies and lawyers too, frankly, were a bit lost because there was no carrots or no sticks. So yes, with the companies with the employees, with employee count above 50 do have to adopt the whistleblowing system, but then what? And the company, being a corporate animal, doesn't always see the benefit. And I think that there are quite a lot of legal benefits that we could adopt just to encourage companies to take up the system. One of the most obvious benefit, which partially is already in place, for example, comes from the public procurement sector, where when a company is found guilty of violations of competition law, then they can adopt certain measures to demonstrate that these violations will unlikely to happen again. And in that system, of course, the whistleblowing procedure is something that would be very beneficial, especially if there's a cartel or another behavior that does relate to people coming together and agreeing on something that is not on paper and normally is not obvious. And so we could do that also for other things. For example, we could do that for incidences when there is a criminal violation. We could encourage criminal sentences lower, or the specific mechanism that we do have in place for companies to be milder if, for example, there is an effective whistleblowing system in place. So more carrots would be absolutely great. And well, for the sticks, we do have those in the law. In fact, they are, from the first cases that we have, they are applied quite effectively. And here, I think the very good news is that the court system in Latvia is actually very much attuned to the values of the whistleblowing law and also to the directive that we have to implement. The first judgments that have been passed, they are very much in favor of the whistleblower, of defending them against any wrongdoing, either that was the employment case or whether that were matters regarding circulation of the information about the whistleblower between various institutions that were, government institutions that were involved in the review of the report. And I think that is very good because, of course, the courts do set the tone, especially when the legal consequences come for any whistleblowing report, and they are, in my opinion, quite on it, and that's good. But there are other actors, and that's maybe rather an open-ended comment that I wanted to make, especially given what is in the last 2 days in Latvia, is that, okay, we do know that the courts are okay with this and they understand the values. And we do know that a range of companies definitely understand the values and have incorporated whistleblowing systems really since way back in 2010 when I started to practice law, and likely even before that. But what about our trade unions, and what about trade associations, and what about our political actors? And that's an open question, whether they do welcome whistleblowing, whether the tone at that top is set well, because it is in the end the lawmakers, the parliament, and the parties that make it up that would adopt any amendments to the procedures law or to the whistleblowers law, including the implementation of the directive, that do have to pass their judgment on what is whistleblowing and how can we defend the whistleblower. And even though the directive does, of course, give us a framework for what we can or can't do, I don't think that the recent events with the Attīstība party show that whistleblowing, even if it's unclear whether, even if it's not legally whistleblowing under the law, that that is not welcome behavior. And moreover, that such behavior is maybe even punished. So we do have to raise awareness, not only by the legal tools, but specifically targeting the lawmakers. And that is, I guess, the main challenge that we see at this point. And of course, more carrots for companies is always good. That will be so far that, and Laima, over to you.
Thank you very much, Catherine. Before we go further to Amit, we already have some questions from the other sides of screen, if we may say. So I will start with one from the viewers. It is a question to Evita, whether the system is useful if about the usefulness of a reporting system in the case if it wastes time and the huge resources on so-called blank messages. Could you please comment?
Blank messages meaning that somebody simply reports just for, I don't know, for revenge purposes or something like that. Do I understand it correctly?
Yes, yes. Could you please comment?
Yeah, a very good question, actually. Yes, so really we have had our own internal system already for more than 10 years. And honestly speaking, no, we don't experience that. Yes, from time to time, maybe there are, let's say, ungrounded reports, but in general, due to the fact that we really for years have promoted that culture of openness and fairness and how important it actually is, you know, that we have the same values and actually let's say our values and our like the principles how we work and the behaviors which are encouraged or on the opposite not encouraged are actually structured in and implemented by our code of ethics of the company. And this code of ethics is not just, again, a document that gathers dust, but really is a living instrument, which is actually an integral part of employment relationship of all the employees in the company and is applied universally, so basically without any exceptions. And also we carry out trainings on the code of ethics, and so people can't also say, you know, that they have not understood something, and they can always ask. So we really encourage this culture of openness and also create trust of our employees and actually also like other stakeholders, our cooperation partners and so forth. And we also accept anonymous reports, so that goes beyond the law we have in place in Latvia. And but we also apply really these very important principles of confidentiality and also the let's say timeliness of actually reviewing these reports, so that we really create this atmosphere of being objective and confidential and fair. And due to that, I think people like our employees and stakeholders who decide to report something, they actually see that we review these reports very carefully, and there are almost really no attempts to misuse the system. And yes, I've heard actually this question several times with respect to the like newly implemented, we can still say so, Latvian law, but at least our already long-term experience doesn't really show that this system would be misused. But again, I would like to re-emphasize that I think it is really important that we have kind of we work very diligently on creating this culture that actually which probably creates also this this spirit and understanding, you know, what this system is for, and that usually really it is used for like in good faith. And let's say these couple of cases which we might consider as misuse of the system, in any case, you know, it was not like really 100% misused, you know, like misuse of the system. There were still, if it was, for instance, with respect to even like a relationship between people, you know, that there was still something in that, and when, you know, when we have reviewed this, you know, these like maybe smaller items were also solved. So actually, I'm not so sure really that with this let's say kind of culture in the company where this where employees are really aware that they can be like what really the values of the company are, that they would really misuse the system. I believe really in good faith of employees.
Thank you very much, Evita. Now let's move on forward with a small comment from the State Chancellery to Katrina, and then Amit, the floor will be yours. Yes, please. Ines from State Chancellery, comment on Katrina.
Yes, hello, colleagues. I will continue speaking in English. I would like to reflect on what the colleague said about the regulation in our whistleblowing law about internal reporting channels, that it does not really contain any carrots or some punishment in regarding the internal reporting mechanisms, which is absolutely right. I would like to therefore say that at this moment the law is open for amendments, as we all know. The amendments have been prepared by the State Chancellery in August this year, and first comments were received at that point, and further comments coming in, and we are preparing these amendments and reflecting what both private sector or NGOs or other institutions have told us. And so in this light, my idea is that if you can come up with concrete ideas, what could be these carrots or the punishment, and you can propose them in this moment, because the law amendments are about transposing the directive, so they are very broad, as the directive has this whole chapter about internal reporting. And if you see that something we didn't really see, what is in the directive, good things that we could take in Latvia, we're very open to discuss that. And maybe we should, of course, come up with some invitation on our side how to do that. But at this stage, preliminary, I can invite you to see this aspect and use this moment. Yeah. Thank you.
Thank you, Ines. I can see such a great cooperation in future here. Thank you very much. Now, Amit, with your experience, you definitely could tell us more about how to give those carrots, how to encourage reporting and successful utilization of internal control mechanisms. What are the challenges and best practices in your way? Please.
Well, good afternoon, everyone, and thank you for inviting me to participate today. I'd like to thank, in particular, Delna, specifically Ines Taurenia and Ines Kusche of the State Chancellery for really welcoming me to the country. I arrived here a few months ago, and I feel very settled here, in large part due to the friendships and professional friendships that I'm forming. So I want to just take a step back, and I want to talk about the importance of internal reporting mechanisms. Did you know that 43% of illegal conduct that's discovered within institutions is detected by a tip or some disclosure? That is almost 3 times the next most common detection method, which is internal audit. Compare that to a meager 2% of detection that is conducted actually by law enforcement. The vast majority of those tips come from employees. You don't have to take my word for it. The Association of Certified Fraud Examiners 2020 report this year actually made that statistic based upon their research of thousands of cases. Consider that for a moment. Whether we're talking about asset misappropriation, financial statement fraud, corruption, conflicts of interest, these disclosures, or tips, as we call them, by employees were responsible for detecting misconduct within their private and public institutions. So at a minimum, the key to preventing and detecting fraud and corruption within institutions is empowering employees, particularly through an internal whistleblowing mechanism. The Riga City Council actually appeared today. It was Mr. Ivars Edvardson, and he talked about, as did a couple of other speakers, talk about education. Education, awareness, communication, those are all essential. And when we're talking about internal points of contact, it's important, of course, that they have training and education to receive complaints, but not just on the letter of the law, but of course on the spirit and on the gray areas that they're likely to encounter. Because they're going to encounter areas that are not clear-cut, not black and white. So my background is as a prosecutor. I'm a prosecutor from New York City, and I've made a lot of cases based upon whistleblower disclosures. So I know the importance of internal whistleblowing mechanisms, and I'll talk about a few tips in a few minutes about that I have found to be useful. They're very practical, and some of them are pretty common sense. So I hope that there are some contact people here listening. But they really stem from the idea of empowering whistleblowers and following up on what they're saying. So, and I'll talk in a second about the mechanism that we have in the United States, talking about carrots and sticks, and I also have a few recommendations for the law as well that I'd like to discuss. But number one, you have to take whistleblower complaints seriously. There's oftentimes these complaints can be vague, they can be unsubstantiated at first, and people sometimes don't take them seriously enough. But what's crucial to understand is that the complaints, which may seem vague, may only be the tip of the iceberg, so to speak. And there could be pervasive misconduct at a company or an institution that allegation relates to. They can help provide a roadmap of wrongdoing within an institution. They can help make sense of things that don't seem to make sense at first. Just take the procurement fraud, for example. We have a colleague here who is an experienced lawyer in procurement fraud. I've worked in the area of procurement mismanagement and procurement fraud in the United States. I've had whistleblowers explain to me red flags that I should look out for in billing services. I've had whistleblowers explain to me misstatements in a company's qualifications to win a tender. These things may not be relevant or apparent to the naked eye, so to speak, but to a trained person who comes from an institution, They can explain to you what a failure in a test or a quality control actually means to product safety. They can explain forgeries and alterations in documents or the creation of fake documents. They can explain irregularities in electronic accounting data. And they've also explained to me unusual payment patterns. These are all things that we cannot, as prosecutors or people from the outside, really understand without the help of whistleblowers. And it's important that we take them seriously and listen. Number two, you got to build trust. Building trust is essential in every human relationship. It's made more difficult, of course, by speaking to you impersonally like this, but building trust is very important. And whistleblowers are a special category of witnesses, really, that are oftentimes putting their personal and professional lives in peril. So you've got to understand the emotional state that they're in, or you got to be sensitive to them. So even at the initial encounter, instead of starting off with like mundane biographical information, make them feel comfortable, make them feel less anxious. Ask them open-ended questions that are non-leading, and show them that you are listening. Number three, talk less and listen more. Talk less and listen more, right? That's called active listening. Show them that you're listening to them. Number four, maintain trust. You know, you've established trust, now you got to maintain trust. You have to actively maintain trust once it is established, and you can do that by being transparent, giving them updates, honoring your commitments to them, not canceling meetings at the last minute. You know, these people oftentimes, again, are putting their personal and professional lives in peril, and little things can really upset people who are in that situation. Be transparent with them. Tell them what you're thinking. Tell them at the outset about your interactions and your ability or inability to keep their identities a secret. Trust is a two-way street. Whistleblowers, like many witnesses, may have biases or personal motivations. You know, you've got to parse through that and try to verify what you can. Number five, and this is the prosecutor in me, of course, corroborate. That is, find evidence or witnesses that tends to support or reject the statement that the person is making. This will let you test the truthfulness and the accuracy and the authenticity of what the whistleblower is saying. Corroboration is it's really case specific, but it can be in documents, it can be in emails, it can be other people. You know, it can be shown, if it can be shown that two or more people witnessed or had a similar account, and there's evidence that they didn't collude with one another, their statements can be accepted as mutually corroborative accounts of the same event. So really try to investigate. And I say this to any prosecutors listening too. Tom spoke earlier today, and you might have heard a gentleman named Vladimir Radomirovic of the nonprofit journalist organization called Pishtalka in Serbia. That is like really what they do. They try to corroborate the stories to support their clients. And prosecutors can learn a lot from that. In fact, Vladimir teaches prosecutors in Serbia, and he's a journalist. He teaches prosecutors how to investigate these cases arising from whistleblower disclosures. So look, I don't want to take up too much of your time, but I will be glad to discuss some recommendations that I have. But I want to obviously give the floor back to our host.
Thank you very much, Amit. I would love to maybe ask, do you have questions for other participants of the discussion? Maybe you, Amit, have something to ask to Evita, or Evita something to ask for Katrina, or no?
Well, I actually asked the same question I asked before to Tom, if anyone heard me, which was, we have this wonderful law in the United States called the False Claims Act. And the False Claims Act, it allows for various things, but basically it's the number one way we fight corruption and financial fraud in the United States. I personally have done many of these cases, recovered the day before I left the United States, we recovered $860 million fine against the company, criminal and civil liability together in one against the company. And that was a case that we brought under the False Claims Act. That law allows people, whistleblowers, to bring cases in the name of the government, and they do all the hard work. They investigate, they litigate, and then the government can intervene in the case and also take up part of that investigation using its civil authority. Is there a serious discussion in Europe or in Latvia to have such a provision in civil law here?
Evita, Katerina, which one of you would like to comment, please? Yes, Catherine.
Thanks, Amit, for bringing this up. I would say that that is a fairly different system. Latvians would view that as a fairly different system, mainly because the government intervenes in civil cases only when there's already a judgment, and it seems, and it's final, and it seems obviously unjust. So then the prosecutor's office can intervene, asking for another ruling. But then still, it's the court who decide. But I think that very good point is about the corroboration, and there I have heard from my friends at the Corruption Bureau that they are pondering about what methods, tools they could provide for companies in Latvia to be able to corroborate internally or externally certain facts. For example, similar provisions on accounting of various dealings with foreign actors, etc., etc., and well, which would be very much like in the United States, and so on. Because corroboration especially in corruption cases is very difficult. For procurement, I agree with you. It's fairly easy because also in Latvia, most of the procurement processes are electronic. So, for example, in one of our cases, a client received an email from an internal whistleblower, which was because another colleague just put them in CC in an email that was shady, let's say. And then, of course, a whole internal investigation also with us involved took place. In the end, training and other measures, and it was really all in according to their internal whistleblower system, which they later even improved based on that fact. But that's because they had all the emails and everything. But for corruption, for example, it's much more difficult because we do not have to have accounting gifts of noting meetings, etc., etc. And as a general rule, of course, for companies with U.S. Capital and so on, it's different. So I think those are the tools that the companies would consider, because of course that's a cost and so on. And those are the carrots maybe that we can also offer. But government intervention, of course, would be very helpful, but normally the whistleblowers in such cases expect that it's the government who will carry the load due to their procedural and legal powers.
Thank you very much, Katerina. We now have one question also to Amit. How can contact be maintained if the primary goal is to protect person's identity? It's very difficult for the company to hold on a conversation in that cases.
Well, if I understand the question correctly, it's how can you continue to inform the whistleblower of what is going on with their case, or any progress that's being made, or any corroboration that's happening, if the person's identity is anonymous, for example. Well, look, if a whistleblower provides the disclosure it's incumbent upon a company, I think, or any institution to seriously evaluate that disclosure, try to corroborate or understand it better if more information is needed, to seek that information through all available sources. In terms of apprising the whistleblower of the progress of a case or progress, that obviously depends on the facts of the case and facts of, if the whistleblower comes in and deals with a contact person and it's the contact person's obligation to keep their identity a secret, you could still maintain that secrecy of their identity while apprising them of the case. It happens all the time in the United States. We work with witnesses whose identities we keep secret, or victims whose identities we don't publicize in any way, but we keep them apprised of the case. So this is the job, I think, of a contact person, and of course it requires some training on best practices on how to do it.
If I may maybe add from our experience here, for instance, in our code of ethics, we so according to it, first of all, we allow anonymous reports, because in any case, like all kinds of information might turn out to be very useful and actually also based on an anonymous report, like some misconduct can be established, but we also in the text even of the code of ethics, we actually encourage people to disclose their identities exactly because, in case we need additional information, which might be actually sometimes even decisive for establishment of some kind of misconduct, then so we encourage to do that. But in any case, we review all kinds of reports, including anonymous reports. So this is completely true that, of course, if you need further cooperation to find out more details, then of course identity is relevant.
Well, thank you very much. Time for our discussion really ran out unnoticed. It was a real pleasure, and I'm really glad that we were able to find a good steps, a good carrots, how to support whistleblowers for them so that they really could feel like heroes and not to be afraid to talk. Therefore, thank you very much for participating in this discussion. Thank you. Un liels paldies arī visiem mūsu klausītājiem, dalībniekiem par dalību šīs dienas konferencē, par dalīšanos pieredzē un vērtīgajiem padomiem, kā arī darbu, kas jau paveikts un tiks paveikts nākotnē, lai veicinātu uzņēmumu un iestāžu izpratni par to, ka trauksmes celšana ir pašu labā un ka trauksmes cēlējiem tiešām jājūtas kā varonim, kurš tiek atbalstīts, aizsargāts, nevis iebiedēts un nosodīts par savu darbību. Noslēdzam arī konferenci Trauksmes celšana nākotnes līmenis, kas jebkurā gadījumā turpinās dzīvot kā visiem pieejamā ierakstā, tā sagatavotajā ziņojumā par konferencē izskanējošajām atziņām. Šīs 2 dienas ir bijušas tiešām piepildītas un noteikti būs lielisks pamats arī tālākiem darbiem pie sistēmas skaidrošanas un uzlabošanas. Arī 2. dienu iesākām jau agri no rīta ar konferences atbalstītāju uzrunām. Sabiedrības par atklātību dēlna direktori mūs aicināja izzināt labāko praksi un sadarboties atbilstoši iekšējās trauksmes celšanas sistēmu ieviešanā. Viņa ekscelence ASV vēstnieks Latvijas Republikā Džons Leslijs Kārvēls uzsvēra trauksmes celšanas nozīmi korupcijas mazināšanā. Savukārt viņa ekscelence Nīderlandes vēstnieks Latvijas Republikā Hovērs Jan Bildevro mudināja sargāt likumu varu un uzticēties tai. Pirmo sesiju mēs iesākām ar pieredzējušā eksperta Hansa Grūta prezentāciju, stiprinot mūsu izpratni par to, cik būtiski, lai integritātes sistēma atbilst ētiskās līderības standartiem un cik morāli sarežģīti izaicinoši dažreiz ir pieņemtie lēmumi. Turpinājām ar Serbijas pētnieciskā žurnālistikas izdevuma Pištaļka dibinātāja un galvenā redaktora stāstu. Uzklausot vienlaikus gan smeldzīgu, gan iedvesmojošu stāstu par trauksmes cēlējiem. Varējām ieskatīties tajā, cik tieši nozīmīgu lēmumu trauksmes cēlējs pieņem un ko varam kā sabiedrība darīt, lai atbalstītu pārkāpumu atklāšanu. Pirmās sesijas noslēgumā Ines Tauriņa prezentēja monitoringa ziņojumu par iekšējo trauksmes celšanas sistēmu ieviešanu, iezīmējot arī nianses, ka publiskajā sektorā ziņošanas sistēmas kvalitātes uzsvars nereti ir uz saņemto ziņojumu skaitu, savukārt privātajā sektorā uz darbinieku informēšanu un iedrošināšanu. Tāpēc, turpinot otro sesiju, veltījām tieši ieguvumiem un nosacījumiem, ieviešot iekšējās trauksmes celšanas sistēmas. Transparency International Lietuvas nodaļas vadītājs Sergejs Muravjovs līdzās vadlīniju juridiskā atbalsta aizsardzības un labi apmācītu speciālistu nodrošināšanai mūs aicināja arī domāt par empātijas nozīmi. Rīgas domas birokrātijas apkarošanas centra pārstāvs Aigars Evartsons uzsvēra un iepazīstināja mūs ar Rīgas domas ieviesto iekšējo kontrolas sistēmu nozīmi un trauksmes cēlēju aizsardzības nodrošināšanu tajā. Valsts kancelei un valsts administrācijas skola, klausoties diskusiju, jau apņēmās organizēt apmācības kontaktpersonām, lai nodrošinātu vienotu izpratni un pieeju trauksmes celšanā. Otrās sesijas noslēgumā iepazināmies ar finanšu sektoru stāstu. Sarmīta Žēbe no Swedbank uzsvēra, ka trauksmes cēlējs ir varonis un cik svarīgi ir tas, ka to pasaka iestādes, uzņēmumu vadītājs. Privātā sektora pieredzē varējām redzēt, cik būtiska ir trauksmes celšana tieši pašam uzņēmumam, tā augsto darbības standartu un reputācijas pasargāšanai. Dienas pirmo pusi noslēdz ekspertu valsts kancelejas pārstāvs Ines Kuštas un DPD Latvija pārstāvs Mariks Lapiņas diskusiju, kurā viņas akcentēja jau iepriekšējās sarunās dzirdēto un uzrunāja visus, uzsverot mācību nozīmi, kā arī paskaidroja šī brīža pieeju anonīmajiem ziņojumiem Latvijā. Otro dienas pusi mēs iesākām ar satricinošu, emocionālu un satraucošu Pēra Ingvis Monsena stāstu. Siemens Kurmja piedzīvojumiem trauksmes celšanas laikā, dzīve pēc tam un darba vietas sabiedrības attieksmi pret trauksmes cēlēju. Neskatoties uz notikušo, Pērs Ingvis Monsens, ja vajadzēs ziņos vēlreiz, jo vienreiz trauksmes cēlējs ir vienmēr trauksmes cēlējs. Igaunijas Express Media pētnieciskais žurnālists Mārtiņš Laine pastāstīja par to, cik izaicinoši un dažbrīd smagi ir bijis aizstāvēt trauksmes cēlēju par krāpniecību zinātniskās pētniecības jomā, uzsvēra to, cik liela nozīme ir kultūrai un mūsu izpratnei par vērtībām. Tikām aicināt nebaidīties uzzināt, ka kaut kas noticis ne tā, bet gan baidīties, kas notiks, ja tas netiks novērsts. Pieredzes bagātais trauksmes cēlēju atbalstītājs Toms Devains mūs aicināja stiprināt līderību, radīt iekšējās trauksmes celšanas sistēmas, kas nosaka skaidru ziņošanu un stiprina labākos ziņošanas principus un standartus. Noslēgumā uzklausījām 3 ekspertu Evits Gošs, Katrīns Pļaviņš un Amita Kabrau Valas viedokļus par nākotnes izaicinājumiem un iespējām trauksmes cēlējiem. Tika uzsvērta galvenā resursa zināšana un izpratnes nepieciešamība, tāpat tikām aicināt ticēt caurspīdīgumam un ne tikai meklējām veidu, kā likumos piedāvāt burkānus, bet jau pamanījām nākotnes sadarbību šajā virzienā. Šīs bijušas tiešām piepildītas dienas, un tādas tās nevarētu būt bez mūsu atbalstītājiem ASV vēstniecības Latvijā, Nīderlandes vēstniecības Latvijā un Pasaules Brīvo Latviešu apvienības. Diena bagāta, un lai gan konferencei trauksmes celšana nākamais līmenis šī ir noslēdzošā, iedvesma zināšanas un izpratni par trauksmes celšanas sistēmu, tās mehānismiem un varonību, ko uzņems trauksmes cēlējs, būs ar mums arī pēc tās skatoties konferences brīvu pieejamo video ierakstu, saņemot konferences ziņojumu un turpinot runāt un darīt, lai trauksmes celšanas sistēma Latvijā un visā pasaulē tiešām sasniegtu nākamo līmeni. Paldies jums, sargāsim sevi, būsim drošībā un vienlaikus veicināsim mūsu visu drošību neklusējot un atbalstot tos, kuri ir izvēlējušies neklusēt. Paldies un uz redzēšanos!